The petition for appointment of a limited guardian of a minor. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 650. SCAO for State Court Administrative Office, PC for Probate Court. The Form 650 is a form readily available, and we're happy to give it to you free of charge. This form is used when a custodial parent is desirous of having a limited guardianship put in place within the probate court proceedings. As with all of these state court administrative order or office forms, these pre-approved forms, they are created by various statutes and court rules. And as you can see here, MCL 700.5205, as well as the court rules that are reflected there, give rise to the creation of this particular SCAO form. Let's work our way through it to understand how you complete the petition for a request for a limited guardian of a minor, and kind of work our way through the form itself to understand how it's prepared and then filed with the court. In the top left corner is the county upon which the individual resides. Top right corner is the case number, and usually when you're filing the petition for a limited guardian of minor, you don't fill anything in there because they haven't yet assigned the case number. So although there's a spot there for it, it is usually the court that's going to fill in the file or case number. At the top section, it says in the matter of. Now this would be the minor's name, and it's asking for it to be done first, middle, and last name of the minor, and then the last four digits of the Social Security number. The Social Security number is to really provide some uniqueness to the name. So for example, if there's a really common first and last name, it allows for the court to ascertain whether Jane Doe is the same Jane Doe that may have been filed earlier. Number one is really the essence of this petition. It provides, I am interested in this matter and make this petition as custodial parent of the minor. So if you're not the custodial parent, but you're interested in the well-being of that minor in some other way, this is not the correct SCAO form. There's another petition you can file for guardianship of a minor. This is only used when the custodial parent is seeking guardianship for a third party to intervene and provide guardianship-related services in a limited form on behalf of a minor. So again, if paragraph 1 doesn't fit, then use the other SCAO form for the petition for appointment of guardian of minor. And I've done other videos on this particular issue. You can look them up. But this would be the wrong form unless you're the custodial parent. The next section has a checkbox relating to whether there's already an existing action that's within the jurisdiction of the family division of the circuit court. And what that means is there already a custody matter or probate matter involving the same family member? And if there is or was, you'd identify the county, the judge, and whether that matter remains in place or whether it's no longer. Number 3, pretty basic data here. The minor's date of birth, do they identify as female or male, and they're unmarried. Because if there's marriage for that minor, let's say they're 17 and married, for example, this form would not be appropriate. They're unmarried and they reside, and then of course the county and address. And this is to dictate both jurisdiction and the appropriate venue or place within the larger probate court services to which county it should be in. Their present location, because sometimes their permanent address and their temporary location or their present location may not be the same, and sometimes it's actually out of state. So it's really important that that information be correctly identified. If the individual is a citizen outside of the United States, then that little checkbox is identified there and the country is reflected there. And this relates also to jurisdiction for the court to make a determination whether the probate court in the United States, in Michigan, or within that county has appropriate jurisdiction of that minor. Section 4 is whether the person is defined as an Indian child as set forth in the Michigan Court Rule 3.002, subsection 12, and or whether it's unknown. Now, this particular provision relating to Native American children, they use the term Indian child here in the statute, is beyond the scope of this particular presentation. There are some interesting complications, but in my career, we just don't see that many of them that get reflected that way. So I'm not going to spend a lot of energy here on this explanation. But again, with all of these SCAO forms, with all probate-related proceedings, guardianship proceedings, and so on, we strongly urge you to be working with a skilled, competent probate lawyer to guide you through this process, because it's not simple, it's confusing, there are statutes and court rules involved, and only a qualified lawyer is going to be able to explain it all to you and guide you effectively through that process. Section 5 identifies the interested parties that are involved in this petition itself. So again, parent or parents and their date of birth, because they could be a minor, and it's important if their parents are a minor that they're reflected there, the address and appropriate identification to allow for service process. If there's a conservator for the minor and a guardian they would be also reflected there because they're entitled to notice of this petition for limited guardianship. Conservator relates to finances and guardian on behalf of well-being and care. So again, a spot for them. And then this little asterisk section here that says person with the care custody of the minor. So in the event that there's somebody that has the care and custody of the minor at that time, you'd reflect that information there. Again, this relates to the core rule, MCR 5.125, and the relevant statutes and court rules that identify who are the interested persons within the petition, who is entitled to notice of these proceedings when the petition is ultimately filed. On the back side of the form, item 6 is, it's not a checkbox, it's a requirement that you're asserting that the welfare of the minor will be served by the appointment, meaning the well-being, the welfare of that minor would be enhanced, served, benefited by the appointment of a limited guardian. Section 7 also doesn't have a checkbox. It's an assertion. A proposed limited guardian placement plan is attached. And the limited guardianship placement plan is a requirement to the petition for limited guardian. And again, it is a separate SCAO form, and it is actually a plan that identifies the nature of this limited guardianship. What are the limitations? What's the scope of the guardianship that's going to be put in place, both in restrictions as well as time. That particular form is also, I do a video on it. It is a separate process and form, but it's a requirement for the petition for limited guardianship. The next section is the request. So the petitioner, the custodial parent, is asking the court. So in the request, you're making a request to the judge, to the court, of a person, and that's the name section, their address, to be appointed the limited guardian, subject to the limited guardianship placement plan that would be incorporated within this petition for limited guardian. Section 9, it says other, and it really provides 2 lines for you to identify any additional information, requests of the court within this limited guardianship. The below section talks about the consent to the suspension of parental rights, because a mother and or father who have rights as the parents are actually suspending their rights within this petition for limited guardianship. So there's a declaration here that says, I consent to the suspension of my parental rights. A really important thing, because there are certain rights that you have as a parent, and when you're asking the court to have a limited guardian, you're suspending those rights in favor of the limited guardian, assuming that the court appoints that person as the limited guardian of the minor. The declaration under the penalties of perjury that all of the information is true to the best of your information, knowledge, and belief, and a spot for both custodial parents. It may just be that there's one, it may be that there are 2, so there's a spot for both of their signatures and addresses. And it says, a use note, it says, if both parents have custody, each must sign. Now, in the event that somebody is 14 years or older, that individual who is the subject of this limited guardianship petition can actually make a nomination. They have a voice in the request to who should be the limited guardian. So a spot for that 14-year or older minor to reflect their nomination. So if they consent or agree to this petition for limited guardian and the limited guardianship plan, there'd be a spot for the signature to sign. And then a spot also for the attorney to reflect their information in the event there's an attorney that's representing the petitioner. Now on page 1, we mentioned that there was an asterisk, and here's a use note at the bottom. It says, if a parent is incarcerated under the jurisdiction of the Michigan Department of Corrections, the petitioner must also comply with the court rule, MCR 2.004B. So often when somebody is nearing incarceration or expecting to be incarcerated, a limited guardianship plan is also often a basis or an impetus for the petition to be filed, and this particular court rule also has to be taken into consideration. Now, with any petition, it's filed with the probate court. There's a filing fee. It's scheduled for hearing. There's a requirement to follow the court rule and statute for giving notice to the interested parties, and ultimately there'll be a hearing. And at that hearing, the court will have jurisdiction over the matter and adjudicate the petition and ultimately enter an order, assuming that an order gets entered for the limited guardianship. Again, it goes from petition to notice of hearing and service through court order. And it's the order in which the court has made the determination of whether a limited guardianship is appropriate or not. Again, we urge you to be working with a skilled, competent probate lawyer to guide you through these procedures. At the Probate Pro, we are passionate about everything probate. If you have questions about the petition for limited guardianship or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.